Fertility preservation. Fertility preservation. Ethical and legal considerations. Consent and ownership of preserved gametes embryos. Fertility preservation, including the cryopreservation of eggs, sperm, embryos, or ovarian tissue, has raised important ethical and legal questions. These concerns are particularly relevant when considering the ownership, consent, and use of gametes and embryos that are preserved for future use. Below are key points related to consent and ownership of preserved gametes or embryos in the context of fertility preservation. 1. Consent for fertility preservation. A. Informed consent process. Comprehensive counseling. Before undergoing fertility preservation, individuals or couples must be fully informed of the process, risks, and potential outcomes. Counseling should include an explanation of the procedures involved, success rates, storage options, and the long-term implications of preserving gametes or embryos. Clear consent forms. Individuals or couples are required to sign consent forms that outline the storage, use, and possible disposal of the preserved material. The consent form should include the following elements. Voluntariness. Consent must be given voluntarily without coercion. Understanding. The patient must demonstrate a full understanding of the process and potential consequences, including the possibility that the stored gametes may never result in a pregnancy. Confidentiality. Patients must be assured that the information and samples will be kept confidential unless explicit permission is granted for sharing. B. Consent for future use. Use of gametes and embryos. Individuals or couples may consent to the use of their preserved gametes or embryos under specific conditions, such as for the purposes of fertility treatment, e.g., IVF, or for reproductive purposes in the future. Ownership and control. Consent must clearly define who controls the embryos or gametes. This is particularly important in cases where the patient is deceased, incapacitated, or no longer wishes to use the preserved material. Changes in circumstances. Individuals must be informed that they can alter or withdraw their consent at any time before the embryos are used. This is particularly important in cases where one partner no longer wishes to proceed with using stored embryos after a divorce or separation. 2. Ownership of preserved gametes of embryos. A. Legal ownership. Ownership in a couple's relationship. In cases where embryos or gametes are stored for future use, ownership may be viewed as shared by both partners. Typically, consent to store embryos is obtained from both individuals in a couple, and decisions regarding the use of those embryos would require mutual agreement. However, legal ownership can become complicated if the relationship between the couple ends, e.g., divorce or separation. Ownership after relationship. Breakdown. When a couple separates or divorces, the legal rights to use stored embryos or gametes may be contested. In many cases, the use of embryos requires mutual consent, but what happens to the embryos if one partner does not wish to proceed with their use? Legal disputes over the fate of embryos can arise, with some jurisdictions ruling that stored embryos should be destroyed if both parties do not agree to their use. Case example. A well-known legal case in the US involved a divorced couple where the woman wanted to use frozen embryos, but her ex-husband did not. The court ruled that the embryos could not be used without his consent. B. Ownership in the event of death. What happens if the individual dies? In the event of a patient's death, there must be clear guidance on what happens to the preserved gametes or embryos. Consent forms should specify whether embryos or gametes can be used posthumously and whether the wishes of the deceased individual will be honored. Posthumous use of embryos. Some jurisdictions permit the use of stored embryos after a person's death if there is written consent. This can be particularly important in cases of women who wish to preserve their fertility before undergoing cancer treatment or other procedures that might affect their fertility. If the individual passes away, it is crucial to know if the partner or family members can make decisions about the embryos. Case example: the case of a woman who froze her eggs before undergoing chemotherapy led to legal battles after her death. The surviving partner requested to use the embryos to have a child, but the family contested the request, and the court ultimately sided with the partner who had consented to posthumous use. 3. Ethical considerations. A. Reproductive autonomy and choice. Fertility preservation provides individuals with reproductive autonomy, allowing them to make decisions about when to have children. However, this autonomy can clash with ethical considerations related to the disposal or use of embryos, particularly when embryos are no longer wanted. The disposal of unused embryos. After successful pregnancy or when a couple decides not to pursue further IVF cycles, unused embryos must be disposed of. Ethical questions arise over whether embryos should be discarded, donated for research, or used by others. Some individuals feel that destroying embryos equates to destroying potential life, while others believe that unused embryos should be allowed to be donated for research or for other couples seeking to conceive. B. Embryo donation and adoption. Some individuals or couples may choose to donate the unused embryos to other individuals or couples who are experiencing infertility. This raises ethical questions about the donation process, including whether the donors and recipients should be known to each other and whether there should be limitations on how embryos are donated. Embryo adoption. The process where embryos are donated and adopted by another couple to bring a pregnancy to term involves ethical challenges about the parental rights of the donor couple versus the adopting couple. Commercialization of fertility. Fertility preservation, particularly embryo banking, has raised concerns about the commercialization of human reproduction. Some argue that the fertility industry has become overly profit-driven, leading to potential exploitation of vulnerable individuals or couples. Ensuring that individuals are not unduly pressured into freezing their gametes or embryos for future use is an important ethical consideration. D. Psychological and emotional impact. The ethical aspects of fertility preservation also include considering the emotional consequences of the process. The possibility of posthumous reproduction or using embryos years after they were originally created can have profound emotional and psychological impacts. Ethical considerations should take into account the emotional stress and psychological burden on individuals, particularly when dealing with unresolved issues such as loss of fertility, treatment failure. Fourth, legal issues surrounding fertility preservation. A. Jurisdictional differences. The laws governing fertility preservation vary widely across jurisdictions. For instance, some countries allow the use of preserved gametes or embryos after a person's death with proper consent, while others have more restrictive laws. In some countries, the law requires that embryos be destroyed if a couple breaks up or disagrees on their use. Understanding the local legal framework and the individual's rights concerning their gametes or embryos is crucial. B. Legal framework for surrogacy. In the case of surrogacy, the legal status of embryos and the rights of the surrogate must be clearly outlined in a legal contract. If embryos are created through IVF, the ownership and consent to use those embryos must be defined in the surrogacy agreement, including what happens if the intended parent's relationship ends or if the surrogate decides not to proceed. C. International considerations. For individuals or couples who seek fertility preservation abroad or wish to use gametes or embryos stored in other countries, there may be additional legal complications. Different countries have varying laws on the use and ownership of stored reproductive material, and conflicts may arise if individuals or couples move between jurisdictions. Conclusion. The ethical and legal considerations regarding the consent and ownership of preserved gametes and embryos in fertility preservation are complex. Legal issues may arise during the process of deciding who owns or controls the gametes and embryos, particularly in cases of divorce, separation, or death. Clear, informed consent, proper legal documentation, and ethical considerations must be taken into account to ensure that all parties involved are protected and that the process respects the rights and wishes of individuals.